If you do not have an accepting hospital and an accepting physician, you're in danger of violating EMTALA because you haven't followed the regulations. And let's illustrate it by this. Patient is in the emergency department and needs to be transferred to a higher acuity care hospital. There is contact with an accepting hospital. Hospital says, yes, we'll accept the patient. Physician says initially that he or she will accept the patient. Patient's put in an ambulance en route to the receiving hospital. Physician calls up at the receiving hospital and basically says, I renege, no, we don't want that patient anymore. What do? It's out of your hands. They arrive on that hospital's campus. That ambulance comes on the hospital's campus. They have to do the screening exam. That hospital got fined $25,000 for that one mistake because the physician did not want to take the time to come and see the patient. It's not always the burden on the physicians. Don't let me characterize that. But a lot of times there are decisions that are made in which nurses, other staff may say, wait a minute, we can't do this. It's not in the best interest of the patient. So I want to talk a little bit about the captain of the ship, the on-call physician, and what you as nurses and staff members need to have implemented within the hospital. I call it empowering the nurses. And I illustrate it by this case. You think that this can't happen, but it does. A woman presents to the hospital alleging that she's been raped. And so the nurses take the patient back to the examination room and await for the physician's arrival and assessment of the patient. Right thing to do? Right. Except physician walks in and says to the patient, I can't do anything for you. You need to go to the hospital 40 miles up the road. Turns around and walks out. Not a good thing, is it? The nurses were frozen because they did not want to confront the doctor and say, time out, we need to take care of this patient. But because natural circumstances, sometimes the physicians rule. What I want to see, if those nurses had been empowered to go, wait a minute, I understand where you're coming from, doctor. I'm going to talk to my chief nursing officer. If that doesn't work, I'm going to talk to the chief medical officer. If that doesn't work, and I've had it happen where the CEO gets involved to make sure that the patient is properly taken care of. I know it's difficult. It's not easy. But you need to have an outlet for yourselves when you know that the patient is not receiving the care that he or she should. I'll tell you the rest of the story. Physician goes out to the person making the electronic record and says, can you make this patient disappear as if this patient never came to the hospital? So, what do you think the receiving hospital did when she shows up and she's got the original wristband of the first hospital? Yeah, that hospital got in really deep trouble. But had those nurses had the ability to go to a higher authority to be able to do that, it may have saved that patient, and it may in certain circumstances save the patient's life. In this case, I don't know what the disposition of the patient was, but I know that hospital regretted it terribly that they didn't follow the proper procedure. Acceptance receiving hospital, physician reports, Appropriate transfer, key requirement. So most emergency medical conditions would be transferred by an ambulance. Would we all agree? Well, that would be true. So you have to make the appropriate mode of transportation available to the patient. Okay? You got to include all the medical records for that particular patient. If you have lab tests that come in an hour later, you still have to forward those lab tests to the receiving hospital. All of that makes sense, except when you have a recalcitrant attorney that maybe is in an emergency medical condition saying, I'm not going in an ambulance. I don't want to pay for it. I want to go in my car. What do you do? Tell me. What do you do in those cases? Formed against medical advice. Okay? So there's a couple of forms that are required. In those instances where they demand to go by their private vehicle or with mom or pop or whatever it is, you better document the living daylights out of the reasons why they don't want to go by an ambulance. That's the only thing that's going to save you.
And also if you have somebody else that's a witness that's on your side, or one of their relatives.
He's making a very good statement, and that is the more witnesses that witness that, the better off it is, and they better document it, because guaranteed they're probably going to get reported for an inappropriate transfer. I don't want to harp on that very much, but there is a lot of situations that occur, especially in the psychiatric area, where you don't have a psychiatric capability, like perhaps you don't have that capability. You can sedate the patient, perhaps stabilize the patient, but the ABC hospital down the road has a psych unit. And so you've done the medical screening exam and you've done the psychiatric screening exam, but you don't have the hospital that's willing to accept the psychiatric patient. They may accept the medical condition, but they may not be able to accept the psychiatric patient. What? Ambulance, the car arrives on the hospital's premise. Doesn't make any difference whether you're on diversion, whether you don't have the capability, whether you don't have the capacity to treat that patient. Once that ambulance hits the parking lot, EMTALA applies. And so the more screening exams that you have, the more documentation that you have to have. Well, let's talk about helipads. I don't know where that is in the slide deck, but we'll get to it somewhere. Your helipad out there, it's on hospital property. I understand that it's the practice that if an ambulance is awaiting a helicopter, that your policy is to bring the patient in and have the patient examined in the emergency department. Other hospitals, that may not be the case as you leave and go to other hospitals. If the helipad is utilized for the sole purposes of awaiting a transfer of the patient via a Lifeline helicopter, for example. So the ambulance comes in with the patient, they're awaiting the Lifeline helicopter, and there is no request by the physician or the EMTs for the hospital to come out to the emergency or bring the patient in to the emergency department or have the patient come out to see the individual, EMTALA doesn't apply. But if there is a request from the ambulance crew to have an assistance from the emergency department, EMTALA does apply for that case. A lot of them are just merely in the larger metropolitan areas. They're just used as the stopping point for ground to air transport. So one of the things that I want to illustrate about why transferring a patient can cause a lot of problems is this case. And I think I talked about this in the first session. But in a sense, it's very tragic. Physician did the right thing. I'll tell you the end of the story first. Physician did the right thing, but the hospital got fined. So we go back to the beginning. Patient cuts their foot on broken glass. He believes that he can treat it with Coca-Cola. Coca-Cola is going to take care of the infection. Well, that infection causes him to lose one of his legs. Gangrene sets in. He had been to this hospital's emergency department probably no less than 20 or 30 times. I represented that hospital. The physician knew that patient and knew that the only thing that could save that patient's life was to get the patient to a higher acuity hospital, transferred, and that it would require to save his life an amputation. And the patient did not want to have the amputation because he believed that what he was doing was going to save his life. So, on the video, hospital's security camera, you see the emergency department physician actually running down to the ambulance outside the ambulance, hospital's ambulance door. He opens up the door and talks to the ambulance driver and says, look, it's stat. You got to get this patient up there to save his life. Go up 30 miles down the road, slams the door, ambulance takes off. Anything wrong with that? The government thought so. Doctor didn't put eyes on the patient. Didn't take the time to open up the back door. Was the physician wrong? No, he was doing the best thing he could for the patient. At least that's my opinion. Government didn't think so. Fined the hospital, a critical access hospital, $25,000. Almost bankrupt the hospital. The OIG are not tolerant people at all. They make up their own rules as they go along. How many people in here like the IRS to come and see them? I don't see any hands. You don't want the OIG to step into the case as well. Okay, physician's duty. Let's talk about an on-call physician. And in your policies, procedures, they're required to report to the hospital within a reasonable time, as defined in your policies and procedures. A lot of times, I don't recommend, and I think I've told Nancy this as well, I don't like to see in there the physician, on-call physician must respond within 30 minutes. Because it locks you in. What if you're 31 minutes? 32? I like to have a range. The government doesn't like that, but I don't care. I want to be able to have a range to allow flexibility for the physician. The higher acuity level emergency medical condition that the patient has, that time may be shortened. But they must report within a reasonable period of time. If they can't report, what's your backup? Appropriate transfer. If they're unable to come, there may be 18 inches of snow on the ground. That on-call physician can't make it in. You do the best that you can under the circumstances, but you don't do what this physician did, not once, not twice, but 3 times. He failed to respond to his page, continuous pages. For 45 minutes, he failed to respond. And you know what his excuse was? I'm in the shower. I didn't hear my pager go off. So, what is the hospital supposed to do? Hospitals should not tolerate a behavior of any of the staff or the physicians for failure to do their responsibilities. Now, I don't mean to say, and what I look for, because the governing body is the one that's responsible for this, I want to see that the hospital has taken some type of disciplinary action on the physician. And it may be, and I look at it at 3 stages. 1, a written letter of explanation to the ED department chair. 2, a written explanation by the physician why they didn't come in to the chief medical officer. And the third one is, Doc, we're going to suspend you for 14 days unless you abide by what we want to do. Nobody wants to see that, but you would be surprised at how many times the hospital will not discipline the physician. Remember what I told you about the neurosurgeon that was 100 feet away from the emergency department? The government didn't do anything against him. and neither did the hospital, because they didn't want to step on the doctor's toes. What did it result in, potentially? In reality, the patient died. He may have saved the patient's life had he decided to come in. Receiving hospital. You don't have to self-report yourself if you think you violated EMTALA. But sure as green apples, a patient arrives here and you haven't had the call and acceptance, all the requirements, and you feel that hospital dumped on you, you have an absolute requirement to report that other hospital. Generally, it's within 72 hours. I like to have an investigation. I want to see what the totality of the circumstances are. There may be miscommunications. There may be variables in there that, and I'll be honest, and even though I'm on tape, I will say I want to avoid hospitals reporting other hospitals. Why? Because both of you get into potential trouble. Certainly the hospital that sent you in an inappropriate transfer is going to get nailed, but a surveyor is going to come in and they're going to look at your policies, practices. In other words, it's open door. So you get into mud wrestling contest with a pig when you do that. But hospitals have recently been cited by the government for failure to report. Talked about the captain of the ship. We spent some time talking about the on-call physician, so I am not going to belabor that point unless anybody has, any questions. This slide is to show that there are specialty hospitals. Remember I told you that heart hospitals with no EDs and orthopedic surgical hospitals that don't have EDs have EMTALA responsibilities. There are certain hospitals, certain specialty hospitals that they have no choice. They have to accept the patient. That would be burn hospitals, children's hospitals, trauma hospitals. In other words, there are certain hospitals, no matter how full they are, no matter whether they're on diversion or not, they have to accept the patient. So here's what the government thinks. I have to take a big swallow on that one. CMS comes in and says, you didn't accept that neonatal patient and you're required to accept them. Well, we're on diversion. We're all full. Here's what the government thinks. The government asks the question of the hospital, what do you do in case of a mass emergency? Oh, wait a minute. We'll line the hallways with beds and we'll do the best we can to take care of the patient. Gotcha. They'll look to see what the capability is. So don't do what this hospital did in those circumstances. Okay. Patient presented, an ambulance came to it was on the hospital's property. Okay. Hospital claimed it was on diversion. So, couldn't see the patient, and the nearest hospital was 22 miles away. Patient died en route. OIG investigated. Not only was the hospital on hospital the ambulance on hospital property, but they weren't on diversion at all. They just didn't want to see the patient. Cost them $52,000 for that mistake. You know, the cases that I just talked about, they've happened within the last 3 months. If you think that it can't happen, it can. I want to avoid that. We've talked about ambulances. I think that that's relatively clear. The helicopter, I think, is the next slide. Yes. We've talked about that issue. Does anybody have any questions about that Yes, sir.
Maybe not about that. This may or may not apply to EMTALA, but I wanted to mention that in general comment. So I work in a separate office at off-site. Oftentimes I'll have patients in my office who decide to send over to the hospital, okay, maybe 5 minutes by drive away. And depending on the acuity of the situation or what's going on, I'll either say, get in your car and go to the hospital, or sometimes I'll say, you gotta wait for the ambulance. Do you have any general thoughts about that sort of strategy? I mean, does it become, send everybody by ambulance, or just the way I'm doing it?
I know it's not going to surprise you, but I got a lot of responses to that question because it's a good question. The question is, as I understand the question, you're an OB physician in your private office. You're seeing a patient that you believe needs to receive hospital care. And there's a decision that is made perhaps jointly by the physician and the patient, but the patient goes by their vehicle and comes to Memorial Hospital. One scenario. You indicated that based upon the acuity level, you may say, take an ambulance. Does EMTALA apply to a private physician office? No. Does EMTALA apply to a hospital-employed physician office? If it is what they call a provider-based department of the hospital and off-site, and you are billing your pro fees on the 1,500, but you're billing site of service 22, and you're acting as if the hospital, EMTALA applies to you in those circumstances. Generally, EMTALA doesn't apply to private physician offices, but in certain cases, you have to make sure that, do you have a responsibility to stabilize every patient that you see? You can't do that. That's why the 911 plus really applies in your particular situation. But most private physician offices, EMTALA does not apply, even if they're in the main hospital's confine. You're leasing space to the hospital. But if you're provider-based and meet the requirements, EMTALA applies. Does that help?
It does. Again, I don't know if this is peculiar to EMTALA or your area of expertise, but anytime I send a patient over, regardless of the acuity, it always worries me that if I send her by personal vehicle and say, you're going to be away from medical care for this allotted time, and say something happens, even though I don't think it's going to happen, is that a risk to me as a, saying, hey, doctor, you got this patient, you said she needs medical care, you let her get in her Chevy Chevette, and that breaks down on the way. So, just generally, I know it's probably not an easy answer to that, but generally, what do you?
Well, here are my general thoughts. We're not talking about EMTALA can I say that word, applicability? No. But what we're talking about is the risk of liability on the part of the physician. And I think that in the sense that if it were to be taken to a jury and you've made the appropriate initial diagnosis, and let's say you've recommended go to an ambulance, but the patient doesn't want to go by ambulance. Why? Because maybe they get charged for the ambulance fee. It's more convenient to go in my own car. As long as you've made the proper assessment and the kind of documentation you would normally have as a physician, there's risk. But I think you've mitigated that risk by explaining to the patient why it's beneficial for you to take the ambulance. Now, let's talk, which kind of leads into a situation. Let's say that you've done a medical screening exam and you determine that the patient's not in an emergency medical condition, but you've done the test, you've run everything that you would normally do, but you make a big misdiagnosis. Misdiagnosis is not going to be culpable under EMTALA. People make mistakes. I make mistakes. Everyone makes mistakes occasionally. But just because a patient dies, and sometimes there are cases where there was a misdiagnosis, it just happens. The government can't come in, and there are civil cases, many civil cases, where a plaintiff's attorney will charge the hospital that it failed to comply with EMTALA, and then they also sue for damages. A lot of those cases are thrown out, number one, because EMTALA doesn't apply, because you did do a screening exam. You did your best efforts to do that. But number two, it may have been malpractice, and therefore civil money penalties, would apply by the court. But we want to defend, we want to keep EMTALA out of that for reasons that I'll tell you in a little bit. Registration. Okay. We're going to try to include everybody in the hospital to be aware of what their requirements are. So you say, well, registration, how does EMTALA apply to that? Let me share with you the story. 16-year-old female presents to the hospital's emergency department. She's complaining of abdominal pains, cramps. So she goes to the screening triage area, take a little bit of the information from her, but then the hospital sends the patient over to registration. So she and her boyfriend go over to registration. Registration person starts filling out the forms, didn't ask about insurance, asked her how old she was. I'm 16. Well, wait a minute, we can't do anything without parental consent. Can't do anything. Female leaves, comes back with her mother. Obviously she's irate for a number of reasons, but finds out that her daughter's pregnant. It costs the hospital $25,000 because the requirements for the registration individuals are somewhat twofold. Number one, if a minor presents to the hospital and you believe that the minor is in an emergency medical condition, you do not need parental consent. Even if it's mistakenly, but if you reasonably believe that the patient's in an emergency medical, you can examine that patient and begin the treatment for that patient without parental consent. Obviously, in the meantime, you're going to try to obtain parental consent. If the patient is not deemed to be in an emergency medical condition, then I think it's appropriate, even in the stabilization area, you can delay the treatment until you obtain parental consent. But this registration person did not know that the medical screening exam or stabilization of that patient could occur without their parents' consent. Cost the hospital $25,000 because that registration person, unfortunately, she was new. She didn't understand her role in the EMTALA sequence of events, but it cost the hospital $25,000. It's an unfortunate situation because it was a critical access hospital. Critical access hospitals can ill afford $25,000, hit their bottom line. That's how important registration people. So, what's the common question most people will ask registration? Patient comes in, what's the most common? There's two questions that a patient asks, I think, to either registration or to the emergency department. How much is it going to cost? And how long do I have to wait? How do you respond to that? You need to educate and have staff be able to answer those particular types of questions. Number one, avoid asking for financial information at all costs if you can. Sometimes it's just totally unavoidable. In those types of cases, if the patient says, wait a minute, I don't have money to pay, and turn around and walk out of the hospital. Have you potentially violated EMTALA? You doggone right you have. Okay, what do we do in those types of circumstances? What do we do in the type of circumstances that a patient presents into the emergency department and asks, how long do I have to wait to see you? And you say, 30 minutes. I don't want to wait 30 minutes. I'll turn around and walk out. Have you registered the patient? No. Have you logged them in? Probably not. What's going to save your hind end? Documentation. What you want to do is note the date, the time, the description of the individual, what they complained of, what they asked, and I tell you that it has saved a number of hospitals because they have done that. Because they'll go down the road to the other ABC hospital and they'll say, you know what, I went to Memorial Hospital and they told me it's going to be an hour and a half wait, and I just couldn't wait, and they wouldn't treat me. Surveyor, not me anymore, comes in. I'm going to ask the question, where's your central log? Okay, well, there's nothing documented here, but what are the facts and circumstances? What are the description if it falls within that timeline? Oh no, wait a minute, surveyor. We had a patient that fits that description, presented here at 10:10, and left without being seen and against medical advice because they said they didn't want to wait. Good defense. If you don't have it, security cameras are invaluable in hospital. There. Time out for a commercial. Some people say I don't have a sense of humor. I really do, but okay, but so the description is important there. Let me expand a little bit that I didn't cover initially on the medical screening exam. Probably doesn't happen here, but in medium or large hospitals, patients properly triaged, properly receives the medical screening exam, they're registered, everything's fine, but they wait. They're not in an emergency medical condition, at least at that point in time. But they wait 1 hour, they wait 2 hours, they get up and leave. And they have left without being seen. And you have no accountability. Best practices, because the government, but good medical practice would dictate that the medical screening exam is an ongoing process. It's not just a one-time snapshot, because the patient may initially present with non-emergent type conditions, but they may deteriorate. So how do you do that?